Harrington here, folks. This is the Our Practice Makes Perfect podcast. And as you may have noticed, there has been a lull in the action. My apologies. As many of you know, I try to spend summer months in Spain. I have for many years. The heat, the rain, throw in a hurricane or two just for fun. I love you all, but I'm going to love you from Europe during the summer months if it's all the same. And this was actually a particularly good summer to be in Europe. I mean, I went to the French Open, first time in my life. I love tennis, as many of you know. And I caught an Olympic soccer match. Also caught up with my boy who studied music in Barcelona. So great memories. But I'm back now, and I'm here to talk to you about indemnification. I can see your faces scrunching up now. Like, what, Jeff, are you going to sell us insurance now? What is going on here? All right, listen. I wanted to make my first one back after the summer a banger, and this is what I'm going with. So give me a chance here. I promise you, it will make sense, and you will care about this. Part one, let's put this in the real estate context. All right, so this podcast is for small business owners and real estate investors. I'm only going to talk about stuff that you guys care about, so I'm not selling you life insurance. Let's talk about indemnification in the context of owning rental property. This episode is actually inspired by a real case that we are currently defending. Our owner is an Argentine. She lives in Argentina, and she has a rental unit here in Florida. Okay, common scenario, right? See, I told you, this is something you guys are going to care about. Well, as you can imagine, there was an incident. A somewhat ridiculous one, too. The fact pattern may not even be all that relevant to you guys, but I'm going to tell you because it's just kind of amusing. It was the 4th of July, and one of the neighbors had a bag of garbage set out. And, of course, some fireworks landed in the bag and set it on fire. I wasn't there, of course, but my impression is that nobody was in any actual danger. It just made a lot of smoke. It was pretty late at night, so that's probably the only reason it became any kind of an incident at all. My client's tenants, a mom and her son, were asleep in their unit, and the smoke got into their unit. Well, the boy freaked out. I guess he did a full-on Costanza, if you've seen that episode. Instead of exiting through one of the doors, he decided to jump through a window. This is a true story, guys. This is all on the public record. Well, amazingly, the only injury that the kid got was a small cut on his thigh. So, of course, this being the United States, some PI attorney picked up the case, and he's suing. And as PI attorneys do, he's suing everybody that he possibly can. The more pockets, the better. So that means my client, that means the management company hired by my client, the homeowners association. He just added a security company. The more pockets, the better. You get the idea. Like I said, this episode is going to apply to you guys, and if you're in the real estate investment game, sooner or later, something like this is going to happen. Maybe something a little less ridiculous, but something's going to happen. So let's break it down. Part 2, insurance. Now, I suppose the only reason that we have an episode here to talk about it all is the fact that my client did not have liability insurance. Because if she did, then this is what would happen. A claim would be opened by the attorney of the boy who got hurt, and the insurance company would either settle the case or they would hire an attorney to defend the case, right? Either way, though, there wouldn't be any out-of-pocket expenses for my client. My client would offload the entire headache to the insurance company, and of course, that's the kind of indemnification we normally think about. So I guess at this point, I could just say, make sure you have liability insurance, and we're done here. But that's no fun. Here comes the good part. Part 3, agent liability. So, as you might guess, my client didn't have liability insurance on the property. Okay, so that means she's paying out of her own pocket my fees to defend the lawsuit, and if there's to be a settlement, that will also have to come out of her pocket. So, like anybody would do, she's pulling out her hair. I mean, this sucks. And my client says to me, but wait, I hired a management company to take care of this property. I'm in another hemisphere. Nothing that happens in connection with this property is my fault. Get me out of this lawsuit. Her point is that it's the management company's responsibility to take care of this unit. So why is she the one that's having to deal with this now? Question here is she right or is she wrong? Well, as is always the case with legal analysis, the answer is Say it with me. It depends. All right, first of all, let's dive into this. There should be a management agreement between my client and the management company. Don't make me lecture you guys on having written agreements. If you need that lecture, go back to episode 19. Through the management agreement, obviously, you will provide the management company with all the authorizations they need to act on your behalf. That's, one of the main purposes of that agreement, but there's more. Dig a little deeper into that agreement and look for a section that talks about indemnification or perhaps disclaimer. You're going to want to be very familiar with this section and understand how it works. Now again, liability insurance would be the obvious solution to the situation, but let's deal with this conceptually. The issue of indemnification is something that you can negotiate. Have you ever noticed a phrase in some contract that you've signed to the effect of indemnify, defend, and hold harmless? All right, now that's not just to sound fancy. These are actually terms of art, and that's why people need lawyers, because these terms have specific meanings and specific implications. The word indemnify, of course, just means that they're going to have to cover your damages. But if you stick the word defend in there, now we're talking about the cost of litigation. They have to defend any lawsuit against you, which means they're going to be paying my fees and not you out of your pocket. This may not have to be a tough negotiation because many times the indemnifying party, the insurance company, or in our example, the management company, may want to have control over the litigation. So if they're covering your damages, they also want to be able to select a lawyer who's going to defend the case. They also want to be able to determine when to settle, if to settle. Maybe it's a case worth fighting. And if you are going to settle it, upon what terms, they're going to want to have control over all that because after all, they're the ones that are actually paying for the whole thing. But these are all things that can be negotiated and often are. So, it would be possible for you to retain the right to select a lawyer and yet have the indemnifying party pay for it. That happens. It could also be that you retain the right to determine whether or not to settle and upon what terms. That's actually common for professional liability, insurance. So these things are negotiable, and I want you to be aware of these moving parts. Unfortunately for our heroine, she has neither indemnification nor defense built into her agreement. So while the management company finds itself being sued right along with our client, she's on her own for all the expenses. Just one final thought here, and it doesn't apply to this case because I don't think that the management company could be found negligent in any way. It's not their fault the kid decided to jump through the window. But you can imagine a scenario where the whole cause of the lawsuit is something connected with, in our example, the management company's negligence. Okay, so just to recap for a second, we're talking about a scenario where both you and the management company are named as parties in the lawsuit. As we just discussed, if you have that indemnification and or defend language in your agreement, then potentially the management company is going to have to step in and pay for all your legal expenses to deal with that lawsuit. But this final point I wanted to make here is actually something a little different. We're talking about the scenario where the whole basis of the lawsuit is some negligence on the part of the management company. You're still going to get named. You can't get out of that, but you could bring what's called a cross-claim against the management company and try to offload the liability in that way. So that is why you care about indemnification, guys. I told you that this would be relevant to you, that you would care. I'm happy to be back. I think I'm going to start trying to do this more often, where I just take actual cases and talk about them and extrapolate what I think is going to be interesting and helpful to you. So listen, why don't you drop me some comments about experiences you've had or even suggestions you have for new episodes, and I promise I will pay close attention to that. But that's what I have for you on this one, you guys. Recuerda que aquí todos hablamos español, and I will talk to you guys again soon. Harrington here, folks. This is the R-Pod. And